about this argument that, well, no, really, I mean, for example, the hearing in Midland last week. Well, we're sort of the lawyer, we're sort of the state, so we have all of these protections. We don't really have to answer any of your questions. We get to sue you. We get to have 150 hours of depositions from you, but you don't get a single hour of deposition from us. There's a fundamental fairness problem with this position, and I would suggest that there are implications of this position, not just for this case, but for future litigation involving the state. Thank you for your time today and the opportunity to present argument.
Let me ask you one last question that I
Yes.
meant to ask Mr. Cole, but he ran out of time. The way that a civil enforcement action gets filed, as I understand it, is that a particular agency finds out that there's been some violation of a statute, and they refer the matter to the AG's office to file suit. As I have seen it, some of these suits are filed in the name of the agency, and some of the suits are filed in the name of the state of Texas. Mm-hmm. How does that get decided, and who decides it? Do you know?
I will be honest and say I don't know the answer for every context, Your Honor. I know in this context, the statutes that are at issue specifically say that the AG brings suit to enforce the statute in the name of the state of Texas.
Yeah, the agency, in a lot of these statutes, the agency can bring the suit, or they can refer it to the AG's office, or maybe they have to refer it to the. I don't know who makes the decision about who's the plaintiff.
I believe that's usually set by statute, Judge, and I know that there are many cases where the AG would be bringing suit to enforce a statute on behalf of the state of Texas, which is why I say the implications of this issue are significant. Thank you.
Thank you. The case is being submitted. We'll stand adjourned for about 5 minutes while we change the panel.
The dirty lawyer history.
That's right. No one besides
Next case on the docket is 1524-00010, Texas Department of Public Safety et al. Versus Texas Tribune et al. Let's see, I have Ms. Baumgardner for the appellants. Are you splitting your time, or
I've
20 minutes? You can reserve 5 for rebuttal.
I've reserved 5 for rebuttal, yes, sir.
Thank you.
Thank you, Your Honor.
You may proceed.
Thank you, Mr. Chief Justice, and may it please the court. The most straightforward way for the court to resolve this appeal is to hold that summary judgment was improper because the plaintiffs have failed to show that the law enforcement exception does not apply as a matter of law. Now, because that's the heartland of this case, I'm going to spend my time today talking about that. But before I get into that, I think it's important to say a few brief words to clarify the scope of this appeal, so let's start there. The only materials that are responsive to the plaintiff's public information requests are the materials that existed and that DPS possessed on the date they submitted their requests. Now, critically, my friends on the other side have not disputed the legal position that I've just articulated in their response brief, which makes sense because it's based on a couple of black letter principles of Texas law, namely that a government...
They just say you didn't raise it in the
That's
trial.
right, Your Honor, but they're wrong about the waiver argument, and here's why. The PIA, and in particular Section 552.321, which is the section they've sued us under, just waives immunity to the extent that we have to disclose. So because the scope of what we have to disclose is a jurisdictional question, when we can't waive jurisdictional arguments, we can bring that up. But that's the extent of what I wanted to say about the scope of the appeal. I just wanted to say it as a point of clarification from the beginning so we all knew what we were working with. But we can just turn to the law enforcement exception right now.
Let me make
Yes,
sure
Your
I
Honor.
got that. I thought you waived your plea to the jurisdiction in the trial court. Am I wrong about that?
Excuse me, Your Honor, I can't speak. We
So
have
there's
filed a
some
plea to the
deal about,
jurisdiction.
They dropped their requests, and so you waived your plea to the jurisdiction.
There was an agreed judgment, Your Honor, where certain requests were the subject of the plea to the jurisdiction, but there was an agreed judgment where the parties agreed we don't need to dispute those anymore. So then we settled that. But we can still make this particular jurisdictional argument even now, even if we didn't make it in the trial court because it's jurisdictional. But we can just turn to the law enforcement exception now because, as I mentioned, that's the core of this case. And as the court's aware, we relied on a couple of different subparts of that exception, and we can just take those in alphabetical order, A1 and then B1. So let's start with A1, which is the section that says that a governmental body is not required to disclose if the disclosure of those particular records would interfere with detection, investigation, or prosecution of crime. Now, we have met our burden as a matter of law to show that that exception applies because of the district attorney's affidavit. My friends on the other side have raised a couple of arguments against that, but they're wrong about all of them. We know that the amount of testimony, in other words, like they say we haven't sufficiently explained, but that's wrong because in Paxton versus Escamilla, the third court indicated that testimony that's even less than what District Attorney Mitchell provided here is sufficient as a matter of law. In that case, the court was determining whether release of deferred prosecution agreements would interfere with prosecution under A1 in particular. And the court looked at an affidavit of an assistant county attorney, and the assistant county attorney just said that release of those particular materials would interfere with prosecution by generating excess publicity and causing due process problems, and there was a risk of, I think, jury bias, but maybe I'm misremembering. And the third court said that was sufficient. And that makes sense because often, my friends on the other side have mentioned about 4 or 5 cases on page 38 of their brief that say that that amount of explanation that an affidavit by itself isn't sufficient, but those cases actually aren't 108A1 cases.
This is
And
what
yes,
puzzles me about this. So you're arguing there's a fact question and we got to go down for trial. I've never heard of a PIA case, maybe I just haven't been listening, that's presented to a jury.
Your Honor, they're often, the important point that we're making here is just that they weren't entitled to summary judgment on this particular
Right,
motion.
so
It doesn't have to.
You're entitled to go back and have a trial, and I am aware that these cases, open records cases, often tried to the court.
That's right.
But if it can be tried to the court, it can be tried, is there some reason the jury guarantee doesn't apply to these cases?
I might be misremembering their petition, Your Honor. I don't remember them asking for a jury trial at all.
Yeah, I
But-
think it'd be crazy to, because
Right.
the problem is, of course, and the best reputation of whether these documents have anything to do with ongoing investigations or prosecutions is the documents themselves. The documents themselves are always the best evidence. And they cannot possibly, since they haven't seen the documents, make an argument that this document and that document shows that this is just they're trying to avoid being embarrassed. This has got nothing to do with that. So how do they raise that when they can't see the documents?
Well, Your Honor, first of all, I want to acknowledge what Your Honor has said and just say that's just how the law enforcement exception works. We totally understand that it's often not prudent in the context of these very sensitive proceedings, like investigations and prosecutions, like Your Honor mentioned, to reveal those documents to anyone we don't have to reveal them to as a matter of law, and that we would therefore waive our exemptions by disclosing. But Texas courts have regularly relied on this kind of testimony that the district attorney raised. Now, Your Honor's asking how are they supposed to know, and Texas courts have recognized in cases like Paxton versus Escamilla and in Levin also, that sometimes the requesters just don't know, but the best evidence is actually, if short of looking at the documents themselves, which the trial court can do, it can look at the documents in camera, and ORD
Not
also
in this
reviews a
case.
representative. Sir?
That's the problem. The problem in this case is that we're talking about a couple of terabytes of data storage. So according to Google's AI, 1 terabyte of data is roughly 6.5 million PDF pages, enough to fill 1,300 physical file cabinets. Now, I know a bunch of it is video, and that takes more terabytes, but a terabyte of video equals 250 feature-length movies. So I know as a fact that not a single person in this courtroom ever has or ever will look at all these documents. So how in the world are we supposed to?
Your Honor, it's true that this amount of data, it's often not prudent for us for a court to be able to look at that in camera. That's what the representative sample idea is for. ORD employs that, and so courts can do that. But
And the problem with the representative sample is, so the statute clearly says the court clerk, trial court clerk, if you submit something in camera, which apparently you did on thumb drives, is supposed to file that with the Third Court of Appeals. They never did with the Third Court of Appeals. When I found this out 3 days ago, we asked for it. And when the Third Court of Appeals didn't transfer it to us because it had never been sent to them, and so we get it and we can't open it. So now, how are we even supposed to look at the representative sample? I'm not blaming you for not requesting it, because as I read the statute, it says the clerk shall forward that to the Court of Appeals, and they didn't. So now, how many PDF pages is the representative sample?
Your Honor, I'm afraid I don't recall the answer to that. But what this court is actually...
You looked through every page of it.
I'm afraid I haven't, Your Honor. But the important thing that the court has to decide is what we're dealing with is actually, did we meet our burden on summary judgment? And we did, because Paxton versus Escamilla tells us that that's sufficient. And so what the plaintiffs...
Let me stop you for a second.
Yes, Your Honor.
Paxton versus Escamilla is from another intermediate court of appeals.
That's right, Your Honor.
So it's not binding on
That's
us.
right.
So you're saying Paxton versus Escamilla is what? It's highly persuasive? Because you're basically saying Paxton versus Escamilla, we followed it, we did an affidavit, therefore we win. And that's not, it doesn't seem quite so simple.
Well,
I guess could you take us through like a textual analysis, since that decision's not necessarily controlling on us, and we're gonna be looking at how to interpret the
Right.
specific language that we've got in the law. Could you just walk us through the language and how that specifically applies to each category that you're asking us to?
I can discuss with the court the language of the statute, yes. But
Yeah.
before I do that, I want to say something briefly about Escamilla, because Justice Field just mentioned it. Your Honor's right that it's not binding on this court, but it's the most on-point case that this court has been given, because the cases that my friends on the other side have mentioned on page 38 of their brief are not 108A1 cases. There are cases about other law, other PIA exceptions, or sometimes not even exceptions. And the reason that matters, Your Honor, is because, as Chief Justice Brister mentioned a few minutes ago, these kinds of proceedings are really sensitive, prosecutions, investigations, and so often it's not prudent to say very much in an affidavit. The DA here, DA Mitchell, said a lot more in her affidavit than the Assistant County Attorney in Escamilla did, and a lot more than ORD requires, I'll say, for the 108A1 exception as well. But that's why we reference Escamilla. It's highly persuasive, and it's the most on-point case that any of the litigants have given this court on this issue, and because their cases are not 108A1 cases.
So both at
Now,
the Open Records Division, Attorney General's Office, trial court, it's not your burden to conclusively prove law enforcement applies. It's just is it to conclusively prove law enforcement exception applies, or to raise a prima facie case that it does?
Your Honor, generally Texas courts have relied on the kind of testimony that we've put forward here, the DA testimony. That's sufficient for us to meet our burden to show that the exception applies as a matter of law.
It sounds like a prima facie case.
The plaintiffs certainly have the opportunity to rebut it. They haven't done that, but before I talk about that, I want to
But-
talk about, yes, Your Honor.
How can they rebut it? I guess that's where
Yes.
I'm frustrated procedurally, is anyone sitting in this courtroom can understand I'm a procedural person. And if you procedurally are on summary judgment, and you have to prove something as a matter of law, and then you have an affidavit that at best is vague as to the how and why that this is going to interfere with the prosecution when the primary suspect is dead. How do you know how far that affidavit has to go to prove something as a matter of law? If it is confusing to me as well, and I got that in your first question, that we're here on summary judgment. You're saying there's a fact issue. That the
She's
trial,
saying there's no fact issue.
well, but the trial court said summary judgment was proper, so if you want to reverse the trial court, you're having to say as a matter of law, it goes the other direction, or there's a fact issue, one or the other, right?
Yes, Your Honor. There are several things in Your Honor's question that I want to address. The most important one to me seems like how procedurally is this supposed to work. There are a few reasons that the plaintiffs were not entitled to summary judgment, but one of the reasons the plaintiffs could have gotten it is they tried to rebut the presumption that public officials act in good faith. They have not attempted to do that.
But
If they
isn't
thought
it-
that, yes, Your
isn't
Honor.
it I mean, does that presumption apply? And I guess, and I know your answer is gonna be yes, but my question is really why? If the very law enforcement agency you're asking for records from is the one that you're questioning whether they actually acted in good faith in the underlying facts of the case, do we get the good faith presumption when the very reason the press is wondering what happened is that they're saying the DPS didn't act properly?
Your Honor, we're not saying that. What we're talking about here is the testimony of the district attorney. My understanding of what the plaintiffs are saying is that no one is disputing whether the district attorney has acted rightly. My friends on the other side can make whatever inflammatory allegations about DPS they'd like to make, but the testimony we're talking about here is the district attorney's, not about whether the district attorney has acted. Nobody's disputing whether she's acted rightly, and that is really important because there are sort of three reasons procedurally that they were not entitled to summary judgment. One of them is the one I just mentioned, the presumption of good faith. The other one is that the non-movement at summary judgment is entitled to have evidence read in their favor, and that's us. And the other reason is the one that Your Honor and I have discussed already, which is that the entity, Texas courts have recognized that the entity in the best position to know what would interfere with prosecution is the actual prosecutor, not a bunch of news outlets. Now, I do want to address Justice Ferris's question about the language of the law enforcement exception, and that exception is actually pretty broad in its language. Interfere is a pretty broad word, would interfere with prosecution without specifics as to how. There's also no time limit in the statute. So what the legislature has done in that broad-ish language is recognize really how law enforcement works as a practical matter. No good investigator worth his or her salt is going to turn over information that could interfere with the prosecution while the prosecution is ongoing. And in enacting 108, the legislature has recognized the profound public importance of, seeking justice to be done through investigations and prosecutions.
So how many prosecutions are ongoing?
Well, Your Honor, some of these things are sensitive, so I can't speak to them in an
No, I
open
mean,
courtroom. But
how many people have been indicted?
But I am aware of 2 officers that have been indicted. Yeah, those are the ones that are public and that are out there. So those are currently going on.
And anything that exonerates them, you would have to disclose under Brady
Yes,
rule regardless.
yes.
So all we're talking about is stuff that would, and anything that implicates them, you'll want to use it to trial again, they'll want to use it trial against them. So what are we talking about? I'm not asking for particular things. I mean, I'm just wondering, body camera footage. It is what it is. It shows what it shows. It's not gonna change. I mean, I understand the problem about witnesses, and we can talk about those, but that is not gonna change. It is what it is, and why does that need to be kept secret?
Your Honor, I'm about out of time. May I have a few
Sure, you
seconds to
bet.
answer the
Well,
question?
and to use an example from the briefing, the radio traffic
Mhm.
going on at the time, was something that's argued should be withheld. So, talk about that.
Sure. So the concerns that the district attorney has articulated are not are more along the lines of this could interfere with witness recollection, like Your Honor said. The fact that the footage isn't really going anywhere doesn't really have anything to do with those particular concerns about potential jury bias or witness recollection, because if those kinds of things are released to the public, they can interfere with public opinion, and the district attorney has testified that it is already interfering with witness recollection. Now, Justice Field, your question about radio traffic footage, that falls more under the B1 category, which is information, internal records that if released, would interfere with the way police officers do their jobs. It can really reveal things about the way officers investigate crimes, patterns they're looking for, the kinds of things that they're saying to each other while they're engaging in these investigations. So that's why that should be withheld under B1 as well.
Well, this is starting to sound like everything, though. I mean, at some point, we have to draw a line that not, every single piece of information that may be picked up in the course of these investigations is necessarily something that, is so pertinent to the investigation that it needs to be shielded. I mean, what do we use to draw the line where we have such a huge volume of information?
I think that what Your Honor has just articulated is true as a general matter. And I think one way that the court would know that is if the governmental body hadn't been specific enough in just explaining what they wanted to withhold. But we have been specific enough for the reasons I've already explained to the court. If the court has no further questions.
I do want to ask a question
yes,
about
Your Honor.
just the temporal nature of the objections to producing these things. So, what happens when the prosecution is over? Do these records become public if someone requests them?
If someone requests them, Your Honor, a DPS and the DA are willing to disclose the lion's share of DPS's own information. Obviously, there are some things that are relevant to officers' training and things like that, and those might be things we wanted to withhold under 108. But once the prosecutions have concluded, then if someone makes a new request, as Your Honor just mentioned, and that's an important caveat here, if someone were to make a new request, then once that had concluded, we wouldn't 108 we wouldn't think was implicated anymore. There might be other exceptions, but 108 wouldn't be implicated anymore.
Thank you. Is Prather, is it?
Yes, Your Honor.
Your Honor, may it please the court. My friend on the other side is incorrect in three very significant ways. One is with regard to the presumptions under the law, two is with regard to the burdens, and three is with regard to the scope. And I'd like to first start with the presumption. Under the TPIA, information is presumed public. That is significant because the legislature has provided that
Except for the following 80 exceptions.
there are a number of exceptions. You are absolutely correct, Your Honor, and they have grown over the years. But even those exceptions under the Act are to be construed narrowly. And that is not what DPS is advocating for here today. Instead, what DPS comes before this court with is an invitation to read into the statute non-existent mandatory exceptions and confidentiality provisions that are not there. And if this court does what they are asking, as Justice Ferris has brought up, they would be cloaking in secrecy the entire investigative file forever, not just for a finite period of time.
Could you tell us of the 2.8 terabytes, how much has actually been disclosed at this point, or is that?
Virtually none. Virtually none. And this is really important. And so they're wrong on this on the presumption. They're also wrong on the burden. Our burden is to establish that we asked for the documents and the documents were not given to us. Their burden is to establish that the exemption applies, and they have failed to do that.
Why
Again,
does the district attorney's affidavit not do that?
the district attorney's affidavit is not specific enough. It doesn't identify any specific documents as to why or how those specific documents or materials would cause an interference with the investigation. And her affidavit, if you
But
look at,
with 6.5 million documents, that's unrealistic. I know you objected to the representative sample, but what in the world do you expect us to do with 6.5 million documents?
I hear you, Your Honor, and I actually think what the trial court did was an incredibly thorough review of all of this. And so let me go back to the why the affidavit is insufficient, and then I'll tell you what the trial court did. So the reason the affidavit is insufficient is under the ORD 252 and under 434, both of which were dealing with law enforcement exemptions. The Attorney General very clearly said when you claim an exemption under 108 and that it applies to an entire file or an entire report, that is simply insufficient. We did, of course, also include case law dealing with this insufficiency of affidavits as well. In the Mitchell affidavit, what is most interesting about this is her expressed concern is about getting a thorough and complete investigation. She's received that. So just to sort of step back a little bit, the shooter is dead. The investigation is complete. A1 can't apply.
Your position, I know you quote Mr. McCraw, or Officer McCraw, but that it's a conclusive fact that DPS's review is complete. There's not a complete final report.
There is a
mentioned.
complete final report. That's the 2.8 terabytes of data. And so that gets into Your Honor's question about...
It's the whole thing.
Right. So that gets into Your Honor's question about, how can we look with this massive information? So, and this also impacts the scope issue, right? So what happened in this case is we had a summary judgment hearing in March. The investigative file was concluded. The investigation was concluded in February. Colonel McCraw testified to that. Then in March, we had our summary judgment hearing. In June, the court issued a letter ruling. That letter ruling is at CR 1610. And in that letter ruling, she asked for DPS to put together a list of proposed redactions organized by category, mandatory exemptions, and any additional redactions required under the law. Okay, that's where this scope issue comes in and where the federal law issue comes in. Nothing was brought up about scope, federal law, nothing, right? DPS submitted their proposed final judgment in July, mentioned nothing about this, and then to deal with the magnitude of documents that Your Honor's concerned about, rightfully so, what the court said is, come back in September, so now we're talking 3 months later, and on September 14th, we're gonna have a hearing, and we're gonna discuss the documents, the magnitude of documents, and I want you to bring with you logs of what all these documents are, and I want you to list in the logs what mandatory exemptions and other confidential under other law provisions that you want to have imposed. So they produced these logs, and these logs are in the record. They're at CR 1978 to 2041. Okay, there's a whole column, mandatory exemptions. Says nothing about FOIA, says nothing about Privacy Act, also says nothing about some of these are not responsive documents because they're after the TPIA request. Nothing. They present to the court, this is the entirety of the Rangers report. They describe it as a complete copy of the Rangers report that is responsive to the requests. They describe it as being 3,000 pages, and then they give us the logs. The court says, okay, this is too much. I need you to give me exemplars. DPS, you select your best documents. This is you selecting, so it goes back to they control all the information, right? You give us your best documents, your best exemplars for each of the categories that you think have mandatory exemptions or confidential under other law. Again, no mention of FOIA, no mention of Privacy Act. Come back to us in another month. So now we're into October. October 12th, we come back. So the September hearing is the third reporter's record. The October hearing is the fourth reporter's record. Fourth reporter's record hearing, they come forward with exemplars. They have 14 categories of mandatory exemptions or confidential under other law. They impose this or confidential under other law under 552.101 4 times out of 14 different categories. None of them mention FOIA, none of them mention Privacy Act, okay? What
But
they,
it is, I mean, they do mention other law.
they do,
Right.
I'll tell you what they mention is they mention common law privacy, they mention homeland security, and they mention criminal history record. Those are the 3 that they graft in under 101. They don't ever graft in FOIA or attempt to graft in FOIA or the Privacy Act, neither of which apply to state records. But instead, they present, these are our best examples to the court. And some of those examples, in fact, the very first example that they present to the court is post-stated after the TPIA requests. So they have made a representation to the court that these are the representative records. And now they come before this court and they say, King's X, some of those are not representative records after all. They don't fall within the scope.
Well, if they're, so I know that you've made the waiver point about the documents that were produced post FOIA request, but if that argument is not waived, would you concede that those would not, that the summary judgment wouldn't have been appropriate to those documents?
No, Your Honor, and here's why. Because courts, what courts do is, as y'all know, courts rule on evidence presented to them. And this is the evidence that was presented to them by DPS. Here are the responsive records. Otherwise, what you would end up having is, you'd end up having this endless cycle of people throughout litigation saying, oh, here's a new TPIA request, oh, and here's another one, new one, today, tomorrow, the next day, right? You'd have this endless cycle. Instead, what courts do is they rule on the evidence presented, and that evidence presented by DPS was 2.8 terabytes of data, the entire Rangers report. In addition, the legislature has actually done exactly what Your Honor suggested in 552.103, where they said for the litigation exception, this is to be decided based on the facts as of the date of the request. That is nowhere else in the TPIA, which means that is not the general rule. Similarly, when it comes to grafting in the federal law, which does not apply to state records, the one time the legislature said, we're going to defer to federal law in the TPIA was in 552.029, dealing with inmate substance abuse facility information. And there they said, we're going to defer to federal law.
But it seems like there would be a huge problem if, you know, you do have these types of investigations where you have state, federal, local, everybody together. If, you know, federal entities couldn't rely on, you know, federal protections for things that they're sending to try to help.
Well, this, you're right in that this was a collaborative effort, but DPS was tasked with leading the charge in this. And DPS didn't notify the federal folks when the original request came in under 305 like they're supposed to do. So what they did was we actually had a summary judgment hearing set. They asked for a continuance. Then in between the original setting and the continued date, then they notified the federal authorities. And then the federal authorities wrote these letters, none of which are evidence. They're not summary judgment evidence. They are purely argument that they try to, again, graft into their summary judgment motion, which they can't do under Texas Rule of Civil Procedure 59. And they characterize it as arguments, and they characterize it as the views of the federal government. And that simply is not appropriate to be grafted into a summary judgment motion where it's not evidence. And if you look at those letters actually do not say anything about the facts as well. They don't attach the documents that they're talking about, which is required under 166 AF. They simply say, you know, we don't want this information to get out. On the logs that are provided in the record, those logs, they list the federal documents. They don't say that there's any exemption that applies to those federal documents. And so you have a trial court that has done an incredibly diligent job going through all of the different materials that have been supplied and represented to it as responsive documents,
Let me
making
ask
this
you,
ruling.
On the, there is, I assume, civil litigation filed by some of the families.
I assume so, yes, Your Honor.
You don't know anything about that?
I know what I have read. Is it part of the record? maybe a footnote to it here or there. We don't represent the families.
And of course, I assume lots of the analysis, attorneys involved and all that kind of stuff, is trying to determine what went wrong and what we can do better next time.
Which is why it's so important
In
for the public to know.
civil litigation, of course, that's all the trial will be about. You know, if you, subsequent remedial measures are all plaintiff's attorneys look for, because then you admit you didn't do this right and therefore you owe us millions. Against the state or the city, you probably can't recover millions, but you can recover something. Now, criminal, that's not as big a problem, because then the prosecutor you exercise discretion. Should we indict more people because they didn't do something right that in hindsight we see should have been done differently and they should have gone in earlier and all this stuff. So I'm just, but of course once we hold it's public, I understand there's no exception for civil litigation usage. It's got to be a law enforcement, but we do have 2 pending indictments, prosecutions ongoing. And again, I'm just wondering, can you help me with the criminal case? Is that going to become the focus of the case? We're going to forget about this young man that shot 20 people, and we're just going to focus the whole trial on the various police officers or agencies did this and that wrong. I assume they'll have to do that in the case with the 2 Uvalde police officers.
Your Honor, I mean, under Brady, don't they get that information anyway?
I'm sorry.
Under Brady, don't they get that information anyway? I mean, that's probably why the district attorney in her affidavit, and even her representatives at the summary judgment hearing, who did argue at that hearing because that was before the intervention was struck, they didn't argue for this information to be cloaked in secrecy forever. What they said was, we aren't advocating for this to be in a vault forever. We just want to get a complete and thorough investigation, which they have. So A1 simply doesn't apply here. And then what now is being argued, and it was not argued at the trial court level, is B1. And B1 is actually more dangerous because B1 is an attempt to cloak the entire file in secrecy forever. So we're talking about the most significant law enforcement failure in Texas's history, that they would like to cloak in secrecy forever from the general public. The public interest couldn't be higher. I mean, as you know, Your Honors.
Well, they've assured us not,
And
so we won't know about that for some time.
except that we cited in our summary judgment brief examples of all the times that they had invoked the rule to prevent the public from having the information forever. And that is part of the record.
Well, here isn't the problem, though, that we have some pretty broad statutory language that we have to deal with when we're looking at the facts and whether there was just a fact issue. And so even if we might like, as a matter of policy, to prefer more openness, more disclosure, at the end of the day, we're kind of constrained to the text that the legislature's given us, right?
And the text that the legislature has given this court is text that they have specifically said should be interpreted narrowly. And in fact, when 108 was adopted, the legislators who were involved in the adoption of 108 specifically warned against this exact issue. They said that that 108 should not be permitted to be used to allow law enforcement to operate under a blanket of secrecy,
Sure.
which is exactly what they're trying to do here. By moving from an A1 argument, which can't apply because the investigation is complete, to a B1 argument, which now they're saying applies to internal records. Now that shouldn't apply to the immutable evidence that Colonel McCraw talks about coming out, the body camera, the dash cams, things along those lines. But what
It sounds to me like what you're saying is we shouldn't believe the district attorney, which of course is a credibility, so we need to go to trial to see whether the trial judge believes the district attorney's affidavit or not. Or we should look through the documents to see whether that's what they do, which is impossible.
I don't
And
think,
so I'm wondering, how do we reject? I think the standard is a prima facie case, and I think the affidavit is a prima facie, raises a prima facie case. And I recognize that is frustrating when you can't have access to the documents, but I just don't know, what would you have us do?
I don't think that the affidavit, it's not a matter of a credibility determination, it's a matter of disagreeing on the law, disagreeing with the
Because
assumption
it
of the
doesn't go
law.
into greater detail.
It doesn't go into great enough detail. It's not sufficient under the law as far as the specificity goes. It
Well,
doesn't
Could you-
meet the
What would it
standard.
have to say, what would it have to say if, you know, they make the argument under Escamilla, in your view, what would the affidavit have to say to meet their burden?
Yeah, so Escamilla is a very different case. Escamilla is dealing with very specific documents. It's dealing with documents that are having to do with deferred prosecution agreements for unexpired terms in which charges can still be brought. That's a whole different animal than 2.8 terabytes of data that is evidencing the biggest abject failure, as Colonel
We'll agree
McCraw
to
has
that.
said it.
That's different. We can't look at the documents, basically.
Right, but there could have been more specificity. There could have been any specificity. And under B1, which is a new argument, it's not one that they made at the trial court level, they provided no evidence that these are internal records or policies or techniques that somehow are going to interfere with law enforcement in the
Let me
future.
Interrupt you and ask just briefly about the district attorney's intervention. Surely she has an interest, if really, good faith or not, if she thinks this is gonna harm her prosecution, and she's got at least 2 people indicted, surely she's got a right to stand up in court and tell the trial judge, don't let this stuff go, it's gonna ruin my case.
So, Your Honor, I think there's a difference between an interest and a justiciable interest. That is a very difficult
right.
word for me. Here she doesn't have the justiciable interest, right? She doesn't possess the documents DPS does, and this goes into the fact that 108 is a discretionary exemption. DPS could produce the documents tomorrow if they wanted to, and the DA would have absolutely nothing to say about it.
Especially if she's not allowed to intervene.
She's not. She's not.
I know, but why? Why?
Because she doesn't have a justiciable interest. They're not her documents. These are not her documents to control one way or the other. She does further complicate the issue, and
Well, there's plenty of other places, like the Boeing case, where, you know, the Port of San Antonio may not care whether Boeing's information gets out. Boeing does, and so they intervene. Now, there's a special provision in the statute that says they can do that but it's not their documents. They don't own the documents.
it's Boeing's contracts with the Port of San Antonio.
Yeah,
Yeah, these are not her records. These are the records that DPS, or the public's records that DPS holds. And here you've got a 3-prong test, right? It's not just she has to have a justiciable interest, which she doesn't, because she couldn't have sued and these aren't her documents, but also she would further complicate the issues. She has,
how?
well, one of the issues that's been brought up is that her investigator, her chief investigator, was on the scene the day of the actual tragedy, right? Another issue is she says that her interests are entirely aligned with the DA's, or with DPS, and so how is her presence essential if it really is just duplicative? She just doesn't meet the 3-prong test, and the abuse of discretion standard is so high that the trial court should be given deference on this.
I'll give you another couple of minutes.
Well, I'd like you to go back and finish your answer on what the affidavit specifically should have said.
Well, the affidavit should have specifically identified any documents. They identified no documents, but any documents that would get out that would harm, that would interfere with the law enforcement investigation or prosecution. Now, she didn't do that, but she also didn't ever mentioned a concern on the prosecution piece of it. She only mentioned a concern about getting a complete and thorough investigation, which she has gotten. So A1, again, can't apply. There's no pending investigation. There's insufficient evidence. B1, there was no evidence presented, so it can't apply. All you have there is you've got a situation where they're trying to bootstrap in, oh, if these policies and procedures get out, that's going to harm us, even though those are the exact policies and procedures that weren't followed that day, that Colonel McCraw has already talked about: Columbine, active shooter training, alert protocol. That's what complicated and compounded the tragedy that day, and that's why Colonel McCraw has been so himself publicly saying this information should come out. The public is in the best place to determine what happened that day.
Thank you, Ms. Fraser.
Thank you.
Ms. Baumgartner, you've got 5 minutes.
May it please the court. There's a lot that I just heard, and I've got about 6 or 7 things I'm gonna try to get through in 5 minutes, so let's see if I can do
ask you
it.
a question? I'm
Sure.
sorry to interrupt your time right
That's
off,
fine.
but is there no B1 evidence?
First of all, Your Honor, I think we need to clarify something about B1. That's actually one of the things I wanted to bring up. My friend on the other side seems to have mistaken the text of the statute. We did bring up B1 with ORD. We did, and we discussed at pages 304, 308, and
Just not in the
312
trial
of the record. We discussed A1 in trial court, but we did raise it with ORD, Your Honor. And also, my friend on the other side seems to think that that B1 doesn't apply here because it's about after the prosecution. I believe she's referring to B2 and A2, which we have not relied on in ORD and are not relying on now. Moreover, my friend on the other side said that A1 doesn't apply to prosecutions, but I'd like to read the text of A1 to the court. Information held by a law enforcement agency or prosecutor that deals with the detection, investigation, or prosecution of crime, ... is accepted if release of the information would interfere with the detection, investigation, or prosecution of crime. Okay. Let's see, and she concedes that, yes, Your
Why
Honor.
would the affidavit have to say how or why the specific documents would interfere with the prosecution of a crime?
Your Honor, saying why would it or why wouldn't it?
Wouldn't the affidavit have to prove as a matter of law that exception applies, that this will in fact interfere with the prosecution?
It has already done that, Your Honor. First of all, my friend on the other side says we ought to have explained particular documents, but often revealing what documents we have or why certain things would interfere with an investigation or prosecution can reveal things about the investigation or prosecution that are better kept private. As Your Honor is aware, these kinds of proceedings are highly sensitive, and sometimes slicing off a piece of the investigation and revealing it can reveal stuff about the slice you didn't slice off. So that's...
Procedurally, it's not possible to present, I mean, I don't know the answer, but the question I'm asking, why couldn't a trial court in their in-camera review have a version of the affidavit that actually explains? 'Cause I'll tell you, I've just having come off the trial court bench, I feel tremendously
Sure.
for this trial court judge.
Sure.
How in the world are you supposed to make a decision
Sure.
with this information, much less a decision on summary judgment? So is that not possible? They're just supposed to take the DA's word for it?
Your Honor, I have a couple of caveats to the answer I'm about to make. Generally, yes, they are. Yes, in that is sufficient as a matter of law. My friend on the other side hasn't actually cited any cases for her position that we needed to say more, and we provided one that's on point, and the reasons she's articulated that Escamilla is different are not material for distinguishing purposes. So generally, yes, that's sufficient as a matter of law. The plaintiffs are welcome to try to rebut the presumption of good faith. And of course, Your Honor, the district attorney is under oath when she makes this testimony, so she can't lie about it. So yes, that's sufficient.
People never lie in court.
Well, they don't, Your Honor, but, well, of course they don't, Your Honor. Okay, next. We can't waive jurisdictional arguments no matter what happens in trial court. We just can't. That's the way jurisdictional arguments work. My friend on the other side said that the court has to rule on evidence presented to it, but it can't do that if it's not allowed to rule on the evidence as a matter of law or if it doesn't have subject matter jurisdiction over those particular requests. She also says that we didn't bring it up in our mandatory exceptions, but responsiveness based on time is not a mandatory exception, so we couldn't have raised it in our mandatory exceptions when we brought our spreadsheets to the trial court. I am trying to make sense of my notes. Next, she, also saying that the district attorney has to name document by document, really vitiates the whole idea of the law enforcement exception in the first place. Now, my friend on the other side referenced a couple of open records decisions that she thinks supports her position, but I'd like to point the court to a couple where all the agency said was, there's a criminal investigation ongoing. In particular, oh goodness, OR 2011-15-545. Great.
Just send us a letter with that.
Great, I will do that. Okay. I'd like to say a few things about the district attorney's affidavit. My friend on the other side is incorrect about what the justiciable interest test is. The Texas Supreme Court has never asked whether anyone is the right defendant in the first instance. They just ask, could this person, if they were a defendant, have defeated the plaintiff's recovery in part or in full? My friend on the other side also says that the district attorney didn't mention prosecutions in her affidavit, but that's wrong. Clerk's record, I believe, page 1158. As the district attorney, I am obliged to see that any potential defendant is accorded procedural justice. There are more to that effect. We ask that you reverse.
Thank you. Ms. Baumgartner, before you go, will
Yes.
you undertake to deliver to our clerk under seal whatever you all gave the trial judge as far as a representative sample, with simple instructions that even I can access it? Because I've tried, spent 15 minutes this morning trying to access it and didn't get anywhere. So I'm sure it needs to be password protected, but it needs to be in something that our government computers will open and we can have access to it.
As I have a government computer myself, Your Honor, I understand. We will undertake to do that. We'll do our best.
Thank you. We'll take a 5-minute break. Thank you for your patience. The last case on the docket this morning is Crowley ISD versus Carl Stoneham. Who's present for the appellate?
David Campbell.
You may proceed. You've reserved some time?
Yes,
Or
Your
not?
Honor, reserved 5 minutes for rebuttal. Thank you, Chief Justice Brister, and may it please the court. In this case, the independent hearing examiner, certified by the Commissioner of Education, after a discovery had been conducted and an evidentiary hearing had been undergone, determined that good cause existed to terminate a teacher's employment contract because the teacher used unreasonable force against a student.
But didn't the hearing examiner use the wrong legal standard?
No, Your Honor. The hearing examiner did not. In this case, the first ground the commissioner used to try to reverse the hearing examiner and the board's decision was by claiming that it was arbitrary and capricious, but the commissioner's reason for that has been a little bit slippery. Because what the hearing examiner found in the decision was that the teacher's use of force was not consistent with the conduct of a person of ordinary prudence under the same or similar circumstances. If you asked a jury question on this, I mean, that would be the jury question, and that would likely be all the court would have instead of the entire decision from the hearing examiner explaining how she reached that decision.
But is that the statutory language from the immunity for use of force statute?
So the statutory language